The U.S. Supreme Court heard oral arguments regarding a case that could affect more than 300 January 6th prisoners and even President Donald Trump. One America's Daniel Baldwin has more.
Today, the U.S. Supreme Court heard oral arguments in a case that challenges the Department of Justice's interpretation of the obstruction count in many January 6 cases. Joseph Fisher of the USA focuses on Section 1512C2. A provision of the Sarbanes-Oxley Act of 2002 that was enacted following the collapse of Enron, obviously focusing on material accounting fraud. The Scotus decision could eliminate some of the federal charges that President Donald Trump is facing in his own January 6th federal case. Paul Kavanaugh of the National Legal and Policy Center, you were in the courtroom listening to the oral arguments. Can you break down what your main takeaway was? How were the justices on the court feeling about the arguments from both the prosecution and the defense?
Sure. Just to give a backdrop here of the charge, this 1512C2 that you mentioned talks about obstruction of a congressional, any proceeding, but it's related to C1, which talks about destruction of evidence. And it was enacted after Sarbanes-Oxley, where Enron was destroying documents, deleting their emails, and so forth. So it was clear that that statute deals with physically destroying evidence. And so what the government's doing here with these January 6th defendants saying, well, the obstruction charge is so broad, we can bring it anyway, even though it's supposed to be tied to actual tearing up the evidence. So the court was saying, well, where were they destroying evidence for what proceeding? And they were saying, well, you know, let's see. Oh, yeah, those electoral count votes that are in that box on the speaker's desk, if they were trying to get that and tear up the ballots, there you go. There's the obstruction of evidence. I mean, that was so bizarre. No one was really buying that. But the main objection was this statute is so broad, because if you're talking about it can be used for obstructing any proceeding, you had Justice Alito ask some good questions, and he said, how about if somebody pulls a fire alarm in Congress and that delays a vote going on the Hill? And we know what that's about. Congressman Brown, who did that. And they hemmed and hawed, saying, well, you know, what was the intent? And was it temporary? Did there had to be evacuation? So it's basically coming down to where the conservative justices were saying, look, there's no limit to this. You can have this statute apply to peaceful protesters. What happened if these protesters were here on Congress, not January 6th, but January 5th? Because the statute says for any proceeding that's not even taking place yet. I mean, this is so broad that they could go after anybody that they want in terms of obstructing a proceeding. So I think we've got at least 5 votes on the conservative side to strike this down.
Now, Paul, was that the initial intent of this specific provision of the Sarbanes-Oxley Act? Was it intended to be used the way the Biden DOJ has weaponized it to go after a lot of January 6ers, more than 300 of them?
Yeah.
This provision has been charged to more than 300 of them, Paul.
Right. No, it did, and that was mentioned in court where Justice Kavanaugh, I believe, saying, well, don't you have these other charges here, you know, assaulting a police officer and all that kind of stuff? Why did you have to get this 20-year statute and try to stretch it to cover that? And they said, well, you know, the prosecutors can broaden the indictment and so forth. But going back to your question, what was the intent of this statute? To go after companies, Enron, who are destroying documents when they know that they're under investigation by the SEC or the Justice Department for doing criminal activity, and they start deleting things. They start telling their employees, hey, don't talk to the government. You're obstructing, an investigation. And so this statute was never intended to cover this kind of a peaceful protest in front of the Capitol that admittedly turned into a riot and kind of a thing. But there's other counts that they could have charged him with, and they did charge him with. But this is the worst provision there because it allows for 20 years in prison.
Well, Paul, we mentioned at the top that this could affect President Trump's own January 6th case. If you are correct in your estimation that the conservative justices are all leaning no, at least 5 of them per se, how would that affect President Trump's own January 6th case?
Well, the January 6th case that Jack Smith brought has 4 counts. And the 2 of the major counts is that Trump obstructed a proceeding in Congress. So if the Supreme Court strikes this provision down, that's 2 counts that go away in the Trump case. And we won't know what the court's going to rule until sometime in June.
Paul Kamenar of the National Legal and Policy Center, we appreciate you being here in studio to break down the Supreme Court oral arguments regarding Section 15C2. Thank you so much for joining us.
Thank you.
For all our viewers asking where One America News is heading in the future, we would like to introduce you to OAN Live. OAN Live is the best way to stay up to date on all of the hard-hitting, straight-shooting, national and international headlines. And the best part is, OAN Live is only $4.99 per month. All the credible, honest, unbiased reporting One America News offers at a fraction of the cost of cable. Just go to OANN.com to easily sign up for OAN Live and stay informed.